Oniadofo memo kwaba wo ba bibia wo hwe Gifted Media wo YouTube sabre na video a ye beka wasemu na wo hwemu election petitioner yero adwoma ma ne NDC ma ko no dia kodan Supreme Court say ondi won asem we say electoral commission asisi omu na first hearing of the main case na kasanse started asem na kaza in pompon so court no na ye dia ba nti full video no a obitimi ahwe na wo hu de course so wo Supreme Court na wo so wati nsema course so Supreme Court nti beja wo sabe sidam wo hwe video no said Gifted Media so kofa program no bibia free courtroom ho na yesu ye de mawi nti jimre na hwe video yi medase.
By the intransigence of our colleague lawyers for the petitioner. You will recall that on the last date of court, that is the 20th of January, the court made definite orders to be complied with by all lawyers in the case, lawyers for petitioner, lawyers for first respondent, and lawyers for second respondent. The petitioner was to have filed his witness statements by the 21st of January 2021. First and second respondents were to file their witness statements on the 22nd of January 2021, incorporated with their submissions on the preliminary objection to have the petition dismissed for disclosing no reasonable cause of action. As was to be expected, the petitioner flatly decided to disobey the orders of the court and was openly defiant even this morning. I must say that as practitioners of the Supreme Court and as lawyers who attend to court regularly, we need to exercise a little bit of restraint in the choice of our language. It's very important because at all material times we are officers of the court. It's unfortunate the language used by my good friend Tony Lithur this morning was a bit offensive. To say that an application before the court has been predetermined, to say the very least, that's unfortunate, coming from my good friend, of course, and a very senior member of the bar. Well, the court did not take kindly to that. As it is now, the court has been gracious and very lenient to the petitioner because they've been given another opportunity to rectify the wrong. The petitioner has been ordered to file his witness statements by close of day tomorrow, which is Wednesday. The petition has been adjourned to the 28th of January for hearing, which is Thursday. Now I must say something. We are all legal practitioners. The Supreme Court is a very busy place. The Supreme Court is not a forum for organized, rehearsed, and choreographed theatricals or melodrama. It's a place for real, hard, and serious legal work. It's not for flurry of literature, long prose, and rather dull English, devoid of any legal merit. I want to advise my colleagues on the other side that if it ain't broken, don't attempt to fix it. We are ready for them on Thursday. Thank you.
The petitioners are gathering materials and have said that every person they have found is within their remit and within the law. We found about four movements and applications. What's the process? Don't you think this will move on before the next day?
No lawyer has an unfettered right to say that any application he or she files is within his remit. That is why we have the law lords. You don't come to court with the preconceived notion of what you think you have filed. The court at all material times is governed by rules, and the court applies its rules to the letter. They have no unfettered right to come to the court with the needless and unnecessary applications they are filing. You, in one breath, you don't want to obey the court. If you were in court, you should have listened to what the judges said. You are coming to court for a discretionary remedy. You have been ordered to file a witness statement. You claim you have filed stay of proceedings, so you disobey the orders of the court. Yet, you file an application as late as yesterday, and you want the court to entertain it. That is not what trained lawyers are taught to do. If you disobey the orders of the court, it comes with these consequences. The court has given them the last opportunity. Let us see what they will do.
You had made a point that you wanted a place to be dealt with expeditions. And this development takes away some 2 or 3 days from the day to then just the deal up to the court. This should be a contest.
Do you want to blame it on us? The one who got the petition is delaying the trial. What can we do as lawyers on the other side? They are screaming that justice is being sacrificed on the altar of expedition. By their conduct this morning, do you think they want this case to be heard rather hurriedly? Don't blame it on us. When they come, ask them questions. Don't blame this on us. When they come, they'll be here soon. You ask them questions. We are trying as much as we can to comply with the orders of the court and make sure that this petition is heard within the 42-day limit that has been set by CR 99.
From the submission of Mr. Chikata following the decision of the court, one could sense some remorse that the court had misunderstood their intentions. Do you still think that this is part of some deliberate design to delay the case, or you think that genuinely they misunderstood what the operation of the action should have been?
Well, my guess will not be as good as yours, but all I can say, I cannot interpret Mr. Chajikate's demeanor in court this morning, whether he has showed remorse or not. All I can say is that he has obliged the court that they will comply with the orders of the court, and we come to court on the 27th. Whatever they think they are doing is their baby, it's not mine. If they want this petition to be heard, it will be heard. But the court has warned them that CR 99 has its own rules, and that if you fail to obey the dictates of CR 99, your petition can and would be struck out. That should be instructive to them.
Thank you, Counsel.
Thank you
very much.
Thank you.
Follow the
Good morning, ladies and gentlemen of the press. I am sure you are all witnesses to what happened this morning in court. The Supreme Court has given an order for the petitioner's witness statement to be filed by close of day tomorrow, and for us to resume hearing of the case on the 28th. But before I go into what has happened today and other matters, I want to record our disappointment with respect to the language used this morning by a senior member of the bar and former president of the Greater Accra Regional Bar, Mr. Frank Davis. The language that he employed this morning is unacceptable in describing the actions of petitioners' lawyers as theatricals, in describing us as persons who intend to be intransigent and disobedient to the orders of the court. I am sure that Mr. Frank Davis knows that all the applications that we have brought are within the framework of the law. You are journalists. Please do a bit of research. Read CI 99. And please tell us where in CI 99 it is said that you cannot bring an application for stay or proceedings. Tell us where in CI 99 it is said that you cannot bring an application for interrogatories. And tell us where in CI 99 it is stated that as a petitioner you cannot bring any interlocutory application before the court. These are all mechanisms that legal practitioners employ, and we have employed them in a way that is not abusive of our rights within the framework of the Supreme Court rules. And so for him to employ that language is most unacceptable, and we take exception to what he said this morning. Ladies and gentlemen, there is a fetish that is being made of 42 days stipulated by law for this trial. Again, I want to refer you to CI 99, which is the amendment to the Supreme Court rules CI 16. Go and look at Schedule 2 to CI 99. The schedule is very clear that the trial is supposed to take place from January to March. Now just do a bit of computation. January has 31 days. If February is not in a leap year, it has 28 days. And then March has 31 days. That's 90 days for you. Was the lawmaker wrong in stipulating this period for the trial? The view we have taken of this matter is simple. That the trial is supposed, the 42 days is the number of days, working days, that the court is supposed to use in discharging the petition. It is not to be computed on a day-by-day basis. I also wish to make it abundantly clear that this is far from being a frivolous and vexatious petition that His Excellency John Dramani Mahama has filed. The impression being created by the MPP, the ruling MPP, is that we came to court with a frivolous and empty petition, and we are just seeking to engage in theatricals so that the petition will not be heard. His Excellency John Dramani Mahama is far from being such a person. If you look at the petition, it has two purposes. The first one is to hold the chairperson of the Electoral Commission, Jane Adukwe Mensah, accountable for a violation of the Constitution. Now, if you have practiced journalism in this country for a period sufficient enough to know that we have never had a situation where the chairperson makes a declaration based upon one figure, issues an instrument validating the declaration based upon the figure that she has used in making the declaration, and then subsequently revises that figure. Repeatedly revising the figure. Now that is unconstitutional conduct, and we want her to be held accountable for that. We are saying that that conduct that she engaged in is unconstitutional. It's not supported by any provision of the Constitution. And again, as journalists, you should be asking her, when she did the revision, were there agents of the political parties there? That is a critical question that you should be asking her. The second purpose of the petition is with respect to the mathematics of Article 63, Clause 4 of the Constitution. It requires that for a person to be validly declared president of this republic, the person must have obtained more than 50% of the votes. Our petition is very clear that His Excellency Nana Addo Dankwa Akufo-Addo, when he was declared president-elect by the chairperson of the Electoral Commission, had not obtained more than 50% of the vote. That is the mathematics of Article 69. And if this is not an important issue, I don't know what it is. And therefore, as journalists, when we file our witness statement, read it carefully, and you will see that this is not an empty petition. They are preempting Ghanaians to think that we are joking in court, but we are not joking in court.
At the start of the proceedings, you realized that your colleague Mr. Lithur was explaining to the court why you didn't file the witness statement. If you could clarify that point.
Yes, we did not file the witness statement because we had filed an application for stay of proceedings. Now, for the layman, that is an application which is brought before the court to stay its hand with respect to everything in relation to the proceedings, pending the determination of a matter that an applicant has put before the court. And you recall that we have an application for review of the decision of the court to disallow our administration of the interrogatories. And that application was fixed by the court itself for hearing on the 28th of January. And therefore, we thought that given the impact of the interrogatories on our witness statement, because if Jane Mensah answers all the questions, they will bear on the nature, content, and scope of our witness statement. And therefore, we said, let us abide the decision of the court with respect to the witness, the review application, and after that, we will incorporate the answers into our witness statement. That is what that is why we brought the application for stay. Now, as Mr. Chikata pointed out in court, there was no intention whatsoever on our part to disobey the court. I am sure in all his life as a legal practitioner, Mr. Chikata has never disobeyed any court order. And this is not going to be the first time that he has done that. And I'm sure Frank Davids and his colleagues know very well that applying for stay of proceedings means that if you take any fresh step yourself, you are undermining your own application. And I'm sure if we had been given the opportunity to move our application for stay, and if we had filed any fresh process pursuant to the orders of the court, the same people would have raised objections, saying that we have taken fresh steps, we have waived our right to have the proceedings stayed. So they were involved in double speak this morning. Yes.
They don't know the some other processes, including the fact that you wanted some additional information to be added to the review that you were asking for. Is that not a contradiction to the fact that you had filed for a stay?
We didn't file another for additional information. Okay? Neither did we file to amend our application for review. What we did was to add an additional legal ground. That is different.
To the yet to be heard
review application. Okay? So that did not in any way undercut our application for stay of proceedings. I don't think so.
Also, the second respondent argues that having filed their response to your statement of claim, you have the back door to file for amendments. I didn't think that it is not.
Well, I don't know how we came through the back door in any way. We have preliminary applications pending, and we want those preliminary applications determined before we file our witness statement. We are not waiting for them to file so that we can then, come through the back door in order to be able to make our case. We knew our case beforehand, and we thought carefully about our case before coming to court. We are not relying on them in order to win this case. Yes. Now, one at a time.
You were given 24 hours the last hearing to file your witness statement. During that particular hearing, your counsel, Mr. Chikata, raised concerns with the duration of the time given. Today, you've been given the same duration of time, which is 24 hours, by those of working day tomorrow. Do you have concerns with that particular time?
No.
The fact that initially you had concerns with the same duration given.
Well, you see, the initial concern that we had related to the compression of the time for case management. The fact that we came for case management and we were not given an opportunity to determine, for instance, how many witnesses we were going to call, how many documents, and the nature of the documents we were going to tender, and so on and so forth. That is what case management is about. And that is what determines the period of the trial. Okay, so if, for instance, we are calling only one witness, the court may decide that that witness should be cross-examined just for 2 days by each of the respondents. Okay, if we are calling 5 witnesses, then we are looking at a 10-day period of cross-examination. So that is why we thought that the compression of the time for case management was not, proper. And then also the fact that we're giving just 1 day in order to file our witness statement. Okay, but we are prepared, and the witness statement will be filed with all its exhibits, by close of day tomorrow.
The court made reference to
Sorry.
Rule 79 of CI 16.
That is so.
Making a point that should this come there again, it will reserve the right to dismiss the petition entirely. What's your assessment?
Well, I mean, we are fully aware of the consequences of Rule 79 of the Supreme Court rules. It's a rule that cuts across from district court all the way to the Supreme Court. And as lawyers, we are very much aware that if you fail to take a step ordered by the court is within its discretion and power to dismiss your application or the case that you have brought. And so we are very much aware of it, but we don't intend to bring about a situation that will trigger the application of Rule 79. The witness statement will be filed tomorrow, and I am very sure that being a public document, the press will have copies of that witness statement.
Also, there's a rule in the Supreme Court and the firm that has Stanley Commercial Court indicating that self-application does not necessarily mean that the proceedings case should be adjourned, should be put on hold. What is your response to that?
Well, I like the fact that you are attempting to be a lawyer, but the fact that came out very clearly in the last hearing. You remember one of the justices asked Mr. Chikata whether by filing his application for review, that is an automatic stay of proceedings. Okay. Now we need. That means that was a hint that we needed to bring a formal application if we wanted stay of proceedings, and that is exactly what we have done. Okay. We didn't depart from the established rules, practices, and conventions of the superior courts. Thank you very much.
Fantastic. Thank you.